our point of view, we thought the argument went well. During the questioning of Petitioner's Counsel, the questions followed many of the points we made in our brief. For example, that all that's before the court today is the broad question of whether or not all petitions in all cases ought to be barred for disclosure, and the issue of the specific petition, the specific harassment claims around the R71 petitions is not before the court. Many of the justices seem to grab onto that point right away. Secondly, they seem to agree with us that the implications of ruling for the petitioners would be extremely broad and really sweeping, because nominating petitions could not be released, recall petitions, initiative petitions, referendum petitions. So again, that seemed to be helpful as well. So overall, we felt it went well. We certainly can see a path to favorable ruling in this case, based on the questions they asked, but you don't know until you know, so of course we'll wait. We only have to wait about up to 8 weeks. That's not very long.
Secretary? I was very pleased with the way it went today in court. It struck me that there was this underlying sentiment that there is such an important value in having an open and transparent government that you really need to have a compelling reason to deny these petitions as being open records. I particularly like Justice Scalia's comment, democracy requires a certain amount of civic courage. I think that sums it up. I learned as a child that with freedom comes responsibility. That includes standing up for your beliefs. And to say the government ought to keep secret this exercise of initiating legislation or repeal legislation seems to me to be the opposite of that standard which we've held in America for years. It does trouble me politically that this group is going around the country trying to do this to undo laws regarding open government and in terms of campaign contributions, expenditure reporting and such. I'm deeply concerned about it, and I'm proud of the job that Attorney General Rob McKenna and his team did today fighting for open government, and I do believe we're going to succeed.
One other comment that Sam's comment reminded me of, one of the cases that gives us a lot of hope that we're going to prevail is the very recent case of Citizens United. Of course, most people remember that case because 5-4, the court ruled that corporations can't be barred from making expenditures within 30 days of an election. But part 4 of that holding, of that opinion, was an 8-1 holding. 8-1, the court said, but the expenditure disclosure is required. We're going to uphold that, and if anyone has specific instances of threats, harassments, or reprisal suggesting that particular expenditure should not be reported in a specific case, they can always come in and ask for a ruling on a case-by-case basis. That's exactly what we're saying in this case. Questions?
Yes, sir. If the court does uphold the Washington state law, do you anticipate making these petitions public right away? What will the next step be?
Well, they will not be made public right away for 2 reasons. First of all, there is a Superior Court decision in place right now blocking the release of these petitions and petitions for 6 other ballot measures that have been requested, and because the judge in the Superior Court is waiting to see what this court does. Secondly, I expect the petitioners will go back to the same district court judge in Tacoma and will ask for an as-applied based preliminary injunction, and then we'll litigate whether or not, in this case, these petitions should not be disclosed.
Are you concerned that the release of these records, if that happens, could lead to, in fact, harassment and retaliation?
I am not particularly concerned, and I'll ask the Secretary Reid to comment on that, but the evidence, I'm not concerned for 2 reasons. Number one, remember that although the petition forms haven't been public, the petition signers, by and large, haven't been publicized, all the donors to the Referendum 71 campaign have been a matter of public record since the donations were reported to the Public Disclosure Commission. And in the record, there is not a single instance of a donor reporting being harassed, threatened, or in any way intimidated. And I think that if someone wanted to be upset in a very personal way with anybody, start with the donors. If you had, putting aside the issue of the campaign manager, for example.
I have extensive experience in this field of elections and initiatives and referenda. I know of nothing in my experience, which goes back late 60s, where somebody has been harassed for signing petitions. And it's important to know that in the state of Washington, these have never been secret. these petitions are out at supermarkets. They're not sitting on counters where you can leaf through and look at them. Their copies are made immediately after they're signed by the people circulating, passed out. And they're observers who can observe as the process is taking place of checking the petitions. So they've certainly been public, and we have not heard of one incident. That doesn't mean it can't happen. And what has happened is we've had petition signature gatherers be harassed. What we've done is we've contacted the police. We have strong harassment laws in the state of Washington. They've cracked down immediately, and I haven't heard of that problem being continued in respect to those petition signature gatherers.
Mr. Attorney General, one of your arguments is that these need to be open to make sure that there isn't fraud and that the voters can be verified. Is that followed through? Has that process been done with these petitions to make sure that these are indeed voters? And can you tell us what your response to that argument was?
Well, of course, the Secretary of State's office conducted a verification process, verifying every single name and signature on every petition sheet. They did that because the bare minimum were submitted, or just over the bare minimum, and they found, I believe it was about 12,000 invalid signatures because of duplicate signing and a couple of thousand people who simply weren't registered to vote. So in our state, we have an outstanding Secretary of State. It's not that often that someone finds errors, but of course it does happen. We cite three instances in Washington State where error, although not fraud, was found. But of course it is both error and fraud that interests the public. And I'd also point out that it's also very good for public confidence in elections when they double check and discover there wasn't a big problem, that the Secretary of State got it right. That's good too, when they're able to verify that for themselves. To trust what verifies, as said in court. Also, we cite in the briefs, and the amicus briefs cite dozens of examples of outright fraud that has been uncovered just in the last 10 years in states all over this country, from Montana to Massachusetts, from Maryland to Oklahoma. So we have plenty of evidence suggesting this is a real concern. All right, thank you very much. Appreciate it.